Section 24. This section of the Code of Criminal Procedure in India outlines the appointment and eligibility of public prosecutors and additional public prosecutors. According to the section, the central government or the state government, in consultation with the High Court, will appoint a public prosecutor and may appoint one or more additional public prosecutors for every High Court. These officials will be responsible for conducting any prosecution, appeal, or other proceeding on behalf of the central government or state government, as the case may be. The central government may also appoint one or more public prosecutors for the purpose of conducting any case or class of cases in any district or local area. The state government will appoint a public prosecutor and may also appoint one or more additional public prosecutors for every district. These officials can also be appointed for more than one district. The district magistrate, in consultation with the sessions judge, will prepare a panel of names of persons fit to be appointed as public prosecutors or additional public prosecutors for the district. No person shall be appointed by the state government as the public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district magistrate. If a state has a regular cadre of prosecuting officers, the state government will appoint a public prosecutor or an additional public prosecutor only from among the persons constituting such cadre. However, if the state government finds no suitable person in such cadre for such appointment, then it may appoint a person as public prosecutor or additional public prosecutor from the panel of names prepared by the district magistrate. A person shall be eligible to be appointed as a public prosecutor or an additional public prosecutor only if he has been in practice as an advocate for not less than 7 years. The central government or the state government may also appoint, for the purposes of any case or class of cases, a person who has been in practice as an advocate for not less than 10 years as a special public prosecutor. It's important to note that the period during which a person has been in practice as a pleader, or has rendered service as a public prosecutor or as an additional public prosecutor or assistant public prosecutor or other prosecuting officer, by whatever name called, shall be deemed to be the period during which such person has been in practice as an advocate. This section of the Code of Criminal Procedure in India outlines the appointment and eligibility process of public prosecutors and additional public prosecutors, which are officials appointed to conduct criminal prosecution on behalf of the government. It also specifies the requirements for these officials to have certain minimum years of experience as an advocate and the process for appointment through a panel prepared by the district magistrate.